Hi everyone, a very good evening to all of you. I am Dr. Vijay Kumar Singh and I am your instructor for this course, particularly on this topic on interpretation of statutes. This we are discussing under paper 2, that is corporate and other laws for live virtual classes, Board of Studies, ICAI. You all have already taken 2 sessions on General Clauses Act. So we will begin with a quick recap on the General Clauses Act so that you have an idea what we covered broadly. And then we will move ahead with interpretation of statutes. As I had discussed before, that General Clauses Act also helps in interpretation. And interpretation of statutes as such is not a legislation. It is basically a tool or a technique by which we interpret the provisions. So over the years, through judicial decisions, through the interpretations by jurists, academicians, we have come to certain norms and rules of interpretation and construction of legislations. And that is what is referred to as interpretation of statutes. So, as such, interpretation of statutes is not a subject or a legislation. However, the General Clauses Act is that kind of a legislation. So, if you want to, categorize what you can say, clause or statute which helps you in interpretation is General Clauses Act. But in every statute, you have some supporting material for interpretation. Okay, that we will talk about it in our this session, and that we call it as internal aids to construction interpretation. And similarly, there is something which is referred to as external aids to construction. These are the two things which we will discuss in our session. But to begin with, let me give you a quick recap on our General Clauses Act, which we discussed in the last 2 sessions. So if you would see, we have discussed the objective of General Clauses Act, what was the focus, what was the background that we discussed. And this is a British era legislation, but still it continues and it is of helpful nature for interpreting the central legislation. I mentioned and specifically informed you that General Clauses Act applies to all central legislation. For state legislations, there are different General Clauses Act of that particular state. We gave you the example also. Please follow the previous 2 sessions for more details on this. And broadly, we discussed our General Clauses Act in the beginning, and I gave you a background also of legislation, how legislation is arranged, starting from short title, then preamble, then definitions, then interpretation clauses, savings clauses, repeal clauses, all these things we discussed. We also discussed the general rules of construction. So what happens when the law comes into operation? Law can come into operation at one go, or it can come into operation in parts. This is something which we discussed in section 5. 6, 6A, 6, 7, and 8, we discussed about repeal of enactments. What happens when there is a repeal or there is a change in a law? What is the process which we follow in interpreting that? And then we discussed about some provisions relating to computation of time, commencement and termination of time, measurement of distance. And if you would recollect, we discussed some of the cases as well around this, gender and number. And then we discussed power and functionaries. So we here try to understand that how the official functions work. And broadly speaking, we discussed that how continuity is maintained in public offices by these provisions. So even if, say, for example, there is a vacancy in an official position of government, then the work does not stop, right? So we saw the different powers which are there for that particular offices. And then thereafter, we discussed about different other provisions relating to order, rules, etc., made under the enactments, and miscellaneous provisions which included recovery of fines, meaning of service by post, citation by enactments, and application of Act to ordinances. These were the things which we discussed in our General Clauses Act. I'm sure we also discussed some of the problems and its solutions, and you people did well while answering the questions. So I'm sure you are now through with this General Clauses Act. However, if there are any questions, I will be happy to take them, in between whenever I open up the floor for questions. Now, let us move ahead and talk about interpretation and its learning outcomes of this particular chapter. So, if you see your course material, it basically tells you that at the end of this particular chapter, you will be able to gain knowledge about the need for interpretation of statutes. I think by now I have given you sufficient justification why you require interpretation of statutes. Second, you should be able to explain various rules of interpretation of statutes. As you can see on the left hand side, there is a chart which tells you what are the overall things which you will be studying here. That is, introduction of relevant terms, importance of interpretation of statutes. And in terms of rules of interpretation, there are primary rules and secondary rules. So we will talk about them. You should be able to describe the various internal and external aids to interpretation. So there are internal aid to interpretation and external aid to interpretation. Aid means basically help. So how you are going to look into these different aids, that is something which we will talk about. And then ultimately we should be able to know or comprehend the rules of interpretation of deeds and documents. So we will talk about all these in the next two sessions. And today I want to build up the base. Tomorrow we will take on Wednesday we will take more questions and try to deliberate upon it. Though I am open to questions today as well. We go by protocol. You have your chat box open. If you have any questions there, you can drop in whenever you feel like, and I will be picking up them one by one. And towards the end, if we find time, then you can also be allowed to permitted to speak, and then we can have discussion as well. So let us move ahead and talk about interpretation of statutes, deeds, and documents. So when we talk about statutes, deeds, and documents, these are three different terms which have been used. So whenever you say statutes, statutes basically means laws. So we are talking about the laws, regulations, and various kinds, irrespective of the source from which they come up. And we have discussed, if you recollect, in my first session on General Clauses Act, we did 13 of the Constitution of India. And Article 13 refers to a number of terms with reference to laws, like it uses notification, rules, bylaws, regulations. All these things will be covered under the broader definition of a statute. So anything which is in the nature of law or something which needs to be abided by the people or the group, that is referred to as statutes. And Article 13 defines law, and everything which comes under that particular purview will be referred to as a statute. So here we are talking about it in a general sense. Now, documents. When I say documents, documents are defined in the Indian Evidence Act, now the Bharatiya Sakshya Adhiniyam, where you will find that the document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. So as you can see the definition, it is circular in nature, but basically in essence, it is trying to tell you that document can be anything. It can be a piece of paper. It can be a placard. It can be a wooden script. It can be pandulipi. It can be any kind of a material on which there are letters, figures, or marks. So it is not necessary that every time there will be a letter. It can be even a mark. It can be even anything that will be referred to as document. So document has a very expansive meaning. But when we are talking about interpretation of documents, we are generally referring to contracts. We are generally referring to legal documents like affidavit, like contracts, like maybe share purchase agreement. For CA, we are referring to many other kinds of documents which you are going to interpret while you are making your making your interpretation or reviewing or working, right? So this is what is section 3 of the Indian Evidence Act, talking about documents. So documents also needs to be interpreted, right? I can give you one example. Now, when we talk about status of a resident in case of calculation of the income tax or maybe FEMA regulations, we are referring to different documents to ascertain whether the person is a resident or not, right? So that is also interpretation. So many a times you will have a document and you will try to interpret it, whether that qualifies for a particular requirement or not. Another example I can give you with reference to documents is charitable purpose. So many a times you get exemption from charitable purpose, and what you would look for, you will look for a document to find out whether it meets that charitable purpose or not. So this is about documents. Then there are third category of document. You can say deed is also a kind of a document. Document is a broader perspective. So deeds are a specific document. Okay, so in a sense we can say statute is also a document, but when I say document as per section 3, it is a broader definition which includes everything. But statutes have a specific meaning under Article 13. But when we talk about deeds, these are basically instruments in writing or other legible representation of words or parchment or paper, and it has an effect of some legal disposition. So when I say deeds, basically it will be including conveyancing deed, sale deed, or any kind of a deed which is purporting to give some effect. It can be even a will, that is also a deed kind of a thing, right? So simply stated, deeds are instruments. Through all instruments may not be deeds. However, in India, no distinction seems to be made between instruments and deeds. So these are interchangeably used. We can say instruments and deeds. Like say, for example, promissory note. It is an instrument, right? So negotiable instrument. So it is an instrument. So these are the terminologies which are used. Now, see, as a CA, you should be aware about these terminologies, because in different legal contexts, these terminologies mean different meaning. Okay. So these are the three primary words which has been used in your course material: statutes, deeds, and documents. I hope now you can make a bit of a distinction. In terms of the generality, you will see documents are more general, then deeds are there, and then statutes are more specific. So this is what is interpretation of statutes, deeds, and documents. Now let us talk about statutes a bit more, because most of the time when we talk about interpretation applies to statutes, because courts will be doing interpretation. And if you would recollect, we had discussed in one of the slides in General Clauses Act that the task of interpretation or job of interpretation is always left to the courts. So the who can finally interpret a document is the court of law, right? And it can give a finding on that particular interpretation. And hence, classification of statutes, when you look at, is important, because different statutes have different nature. Okay. Like, for example, we are having certain statutes which are referred to as codifying statutes. So you will see nowadays we are having a number of codifying statutes wherein we are codifying everything together. So the purpose of this kind of a statute is to give authoritative statement, authoritative statement about what? About the rules of the law on a particular subject, or maybe customary law. These are referred to as codifying statutes. One of the initial codifying statutes, if you would recollect, is the Hindu Marriage Act. So Hindu Marriage Act of 1955, Hindu Succession Act of 1956, these were all codified statutes. In fact, if you will see, Lord Macaulay, at that point in time, the first 4 law commissions under the British regime came up with a number of codifying statutes. So one of the codifying statutes was also Indian Contract Act, if you look at, or maybe you look at the Civil Code of Civil Procedure. These were, though these are procedural statutes also, but these are codifying statutes, wherein you codify the customs and traditions and all those particular things. That is referred to as codifying statutes. Then there are consolidating statutes. So consolidating statutes basically tries to cover and combine all law on a particular subject at one place. The greatest example right now would be labor codes, right? So it is a kind of a consolidating statute. So it has consolidated more than 27 legislations together, and that consolidation has been done into 4 now. So it is a kind of a consolidating statutes, wherein you are trying to consolidate everything together at a place, rather than keeping it scattered at number of places. I have given you an example: Indian Penal Code, Code of Criminal Procedure. These are all consolidating statutes. Then there are certain statutes which are declaratory in nature. So the objective of the statute is to clarify some doubt or maybe declare something. That is referred to as declaratory statutes. So if you say, for example, there are statutes relating to Income Tax Amendment Act, which declares certain things. That is by way of a Supreme Court judgment or by way of some event which has happened. That is referred to as declaratory statutes. It wants to declare something. That is referred to as declaratory statutes. Then we are having remedial statutes. So many a times, if you will see, most of our statutes are remedial in nature. So, and many a times I say that our legislations are framed in a knee-jerk reaction. Whenever there is some problem, we come up with a legislation to solve that particular problem. So remedial statutes. And this you will, come through this particular term many a times, because we will talk about mischief rule. We will talk about the different statutes. The objective is basically for all legislation to remedy some situation. So here, if you have a look at it, granting of new remedies for enforcing one's rights can be done through the remedial statutes. So the purpose of this statute is to promote general welfare or bring social reforms through the system. And these statutes have liberal interpretation. So wherever there will be a remedial statute, you will try to interpret that particular law in the favor of the person for whom the law has come up. Like, for example, you have Maternity Benefits Act 1961. So this legislation, once it comes for interpretation, you will have always a, you will always have a liberal interpretation of this law in the favor of the lady for whom you are interpreting this particular law. Similarly, the Workmen's Compensation Act. So it is there to help the workmen, and that is how the interpretation will happen. Similarly, you have Consumer Protection Act. This is specific legislation meant for consumers, right? And you want to help the consumer, and hence you will not go into the detailed procedure of it when you interpret this particular law. So remedial statutes generally are having liberal interpretation. That does not happen with taxing statutes, by the way. Tax statutes are most strictly interpreted, okay, this way or that way. They will not be in a liberal interpretation. Then coming to other types, there is some statutes which are referred to as enabling statutes. When you say enabling statutes, that means this law enables you to do certain things. Either you enlarge the provision, for example, Land Acquisition Act. It enables the government to acquire a public property for public purpose. That is enabling statutes. So it enables the authorities to do certain things. Similarly, Administrative Tribunals Act. It enables the authority to settle the dispute in administrative realm. Similarly, you have National Company Law Tribunal coming under the company law. It is also a kind of an enabling statute. By the way, I will tell you, you should not get confused by these particular terms. You may have many of these provisions in single statute. So a statute may be enabling, it may be codifying, it may be remedial, it can go all together. So it is not necessary that each statute has to be having only one kind of a characteristics. But primarily, you can see that what is the major feature of that particular statute, whether it is enabling, whether it is remedial, whether it is declaratory. So you have to see it from that perspective. Then there are disabling statutes. So some statutes disable you from doing certain things. Like, for example, we have Child Labor Prohibition and Regulation Act. Now, this is a disabling statute. What it disables? It disables people from employing children. Okay. So this is a disabling statutes. Then there are certain penal statutes. So this is a very easy one. Penal statutes, you all know. We have Bharatiya, initially we had Bharatiya Dand Sanhita. Now it is Nyaya Sanhita. So you have penal code, Indian Penal Code, like that. Then you have taxing statutes. As I referred to taxing statutes just now, tax is a form of revenue and which has to be paid to the government. It can either be on income or the individual earns on any transaction. So a taxing statute does levies taxes on such transaction. So it can be wealth tax, it can be gift tax, or it can be different types of tax. So these are taxing statutes. Most of the times these are interpreted very, very strictly. Then you have explanatory statutes. So there are certain statutes which are there to explain the situation. And the greatest example would be the General Clauses Act. So you see General Clauses Act, it has got the explanatory nature. It does not confer any rights or duties, but it basically tries to explain the legislations. Then we are having amending statutes. So the statutes which basically amends the provisions of law is referred to as amending statutes. And we have seen the nature of amending statutes in our General Clauses Act. And what is the objective of amending statute is to amend the provisions of law which are existing. And then there are repealing statutes. This also we have seen in very much detail. And under General Clauses Act, there are detailed provisions relating to dealing with repealing statutes. So these are different kinds of terms which you will see while you are reading interpretation. I think these terms are not mentioned in your course plan or your course material, but you will come across these particular terms many a time. So you should not get confused about these terms. And hence I thought that I will give you this particular background because many of you may not be from law background. So this will help you in understanding the interpretation better. Let me see. There are some comments here. Okay. So Sayyed, you have asked a good question. That is, to enforce these statutes, is there any need to change constitution? Now, this is actually a philosophical question, and I will touch upon this after some time, so that you will be able to understand better. Okay, I will take this up in a while. Now, let us move ahead and talk about the classification of interpretation. So when I say interpretation and classification of interpretation, your course material bifurcates these into different parts, that is legal and doctrinal. So if you see, it says legal, that where the actual rule of law which binds the judge to place a certain interpretation of statutes. It is doctrinal when its purpose is to discover real and true meaning of the statute. So as we say that there is a legal meaning and there is an academic meaning. Okay. So you have to see that which kind of a interpretation you are applying when you are dealing with a statute or dealing with a provision of law. So if we see here in your course, it has been talked about legal interpretation and doctrinal interpretation. In simple words, we say legal interpretation when we are sticking to the letters of the law. When I say doctrinal, it is going beyond the letters of law and going into a bit of a depth of the interpretation. That is referred to as doctrinal. Now, in case of legal, there are two different kinds of classification. One is called authentic and the other one is referred to as usual. So if you see authentic interpretation, when rule of interpretation is derived from the legislator himself, that is, the legislator himself explains the rule and in detail, that is referred to as authentic. And when the rule of interpretation is derived from some other source, such as customs or case laws, then in that situation, it is referred to as usual. But in your course material, legal interpretation, it is said that if you see the explanation, it says it is authentic when rule of interpretation is derived from legislator himself, and it is usual when it comes from some other source such as customs or case law. Thus, when Justinian ordered that all the difficulties arising out of the legislation should be referred to him for decision, he was providing for authentic interpretation. And so also was the Prussian Code when it was laid down, and judges should report any doubt so as to meaning a statute commission and abide by their ruling is a legal, authentic interpretation. But for your information, we cannot do authentic interpretation every time, because then it will happen that whenever there is a confusion about meaning of a particular term, we have to go back to the legislature and ask that what did you mean about this particular term. So most of the time it is usual interpretation in legal which we follow and not the authentic one, right? So it is very important because you have to see that what does that mean. Okay, so please see it from that particular angle. Then moving ahead, if we look at the doctrinal part of it, doctrinal interpretation is divided into two categories, that is grammatical and logical. So it is grammatical when the court applies only the ordinary rules of speech for finding out the meaning of the words used in the statute. So it is basically, we can say, a black letter law, or you can say the letter and spirit. If letter, whatever is letter written of law, you go ahead with that rather than going into the depth of it. So whatever it is saying, ordinary rules of speech, you read it, and whatever logic comes out of it, you interpret that. Whereas on the other hand, when the court goes beyond the words and tries to discover the intention of the statute, I can give you one example. Say, for example, when the court is interpreting may as may, then that is basically grammatical. But when the court is interpreting may as shall, then there it is using a logical interpretation. I hope you are getting the difference between them. So whenever the court goes beyond the written grammatical meaning or written meaning of the words, that is referred to as grammatical, and if it is going beyond that, that is logical. So these are the classification which is given in your literature. But if you refer to Fitzgerald, who has written book on interpretation, he says interpretation is of two kinds. So it is quite similar. Okay. So when you say one interpretation is referred to as literal and the other one is referred to as functional. Same. Legal, when you say it is legal is literal, and functional when you say basically is logical. So when you are going ahead with grammatical, it is literal, and when you are going ahead with logical, then it is functional. So these are different terminologies which are used by different scholar and jurist in writing their books on interpretation. I will refer to a couple of them in my next slides. So as I told you before, interpretation does not have any sections or rules. So you have to refer to the decisions and treaties and books by different authors. Now, you can see I was referring to author. So I generally refer to the book by Justice G.P. Singh on Principles of Statutory Interpretation. In fact, one of the most classics on statutory interpretation, who all lawyers are looking at that. I also have another book by Mr. K.N. Chaturvedi. He has been the former law secretary, and he has written a book on modern statutory interpretation, and that is also a very nice book by Eastern Law House, and I refer to that as well. So number of examples are given in this particular two books, wherein you can find out on different aspects. Moving ahead, when we talk about interpretation, these are two terms. One is called interpretation and the other one is called construction. So there's a difference. When I say interpretation, it comes from a Latin term that is called interpretari, which basically means to explain, expound, understand, or to translate. So interpretation is basically the process of explaining, expounding, and translating any text or anything in written form. This basically involves an act of discovering the true meaning of the language which has been used in the statute. But when you talk about construction, it is a bit nuanced. But before that, let us look at the definition on interpretation given by Salmond. So it is a very famous definition. Interpretation, he says, interpretation is the process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed, right? So this is the definition of Salmond on interpretation. There is another definition by Cooley, and he differentiates interpretation from construction, and he says interpretation differs from construction in that the former is the art of finding out the true sense of any form of words, that is the sense which their author intended to convey, and of enabling others to derive from the same idea which the author intended to convey. Whereas construction, on the other hand, is the drawing of conclusions respecting subject that lie beyond the direct expression of text from elements known from the letter of law. However, in common usage, we use this term as interchangeably, and it has a similar significance. So not much of a difference between interpretation and construction. So now henceforth, if I use the term interpretation or construction, consider it to be same. So for you people, you don't have to go into the much details of interpretation and construction distinction, because generally these are meant for academics who are going into the depth of interpretation of the statutes and discussing that in for different purpose. So for you people, just you can use interpretation and construction interchangeably. There is no problem. But I have already told you what is the distinction. Okay. Now let us move ahead, and now we move on basic principles. But before I move on to basic principles, if there are any questions till this point, yeah. If you don't have question till the time, I will take the question posed by Mr. Hussain, and he has asked, to enforce these statutes, is there any need to change constitution? Now, see, this question is not very clear or focused. If you can reframe this question, I will answer it. But if whatever I get, I will try to answer that. So constitution of any country is the Grundnorm, right? So that is the basic law of the country, and all other legislations have to be interpreted in line of constitution. So many a times we say that constitutionality of a statute is challenged. So if you will see, part 3 of the constitution talks about the fundamental rights. And it says these are the rights which are basic in nature and that cannot be taken away by the state just for the sake of it, right? So they have to give a strong justification when they take away these particular rights or they infringe these rights. In fact, it clearly says the constitution says that you cannot take away these particular rights of people without proper procedure established by law, as is Manika Gandhi's case it was had. So if any law which interferes with the rights of the people guaranteed under part 3 of the constitution, there can be a challenge in the constitutional court challenging that law on the grounds of constitutionality. It can be done on number of ways. Like, for example, you can say that equality is breached, or you can say that right to freedom is breached, or you can say that it is against Article 21, which is personal life and liberty. Like this, if any of the legislation is in contrast to the rights which have been given to the citizens, then that will be referred to as challenged on the grounds of constitutionality. So this is the interrelationship between different statutes and constitution. And in the constitutional courts, either it is High Court or Supreme Court, you would have seen that there are a number of challenges on the basis of constitutionality. Now, the question is whether there is an amendment required in the Constitution. Yes, there is an amending power under the Constitution itself, wherein the courts can amend, wherein the legislature can amend the Constitution. But this amendment cannot be against the basic structure of the Constitution, right? So this is a larger debate wherein what is basic structure. Basic structure, one of the example I can give you is balancing between judiciary, legislative, and executive. So you have to have this particular balance and harmoniousness between these three wings or three bodies of the governance which is there under the Constitution. So I hope this answers your question. Any other question? Let me see. Yeah. Okay. There are no questions. Okay. Now let me take you to the basic principles. Okay. Statutes come under Constitution compulsorily. All statutes are independent, but all these statutes you need to deal with in line with Constitution. These statutes cannot be contrast to the Constitution. But statutes coming under constitution is maybe not a correct statement. We can always say that all statutes uh, all statutes are um, subject to the constitution, that you can say. Yeah. Okay. Let us move ahead with basic principles. So there are four basic principles of interpretation of statutes. This you will go and know, the importance of these particular statutes, right? So when I say basic principles of statutes, basic principles of statutory interpretation, there are four basic principles. Okay. The first principle is to always go to the intention of the legislature. So whenever you have an interpretation to make, you try to find out the intention of the legislature. What was the intention of the legislature? What legislature wanted when the law came? That is very important, because courts will always go into the depth to find out what is intention of the legislature. We will talk about it in detail in a while. Second important basic principle in interpretation is that statute must be read as a whole in its context. If you would remember my previous class, I told you context is the king. So in interpretation, you have to find out that context, that if a definition is there, it is said in which context. If a particular provision has been said, it is said in which context. So understanding the context is very important. If you would recollect, I was just talking about remedial statutes. So you have to see the context. If it is Workmen's Compensation Act, you have to see the context in which the Workmen's Compensation Act has come up, right? If you have to see the new labor codes, you have to see the context, why these labor codes have come up, right? And you have to again go back to the intention of legislature. This is the second basic principle. Third basic principle talks about if meaning is plain, effect must be given to it irrespective of the consequences. So consequences doesn't matter in law. If the meaning is plain and simple, the effect of that particular law has to be given. You cannot say that it is harsh on people and hence law cannot be enforced, right? So if the meaning is plain, effect has to be given to it irrespective of the consequences. We will talk about some more examples. Fourth one of the basic principles is statute to be construed to make it effective and workable. So you tried intention of legislature, you have read the statute as a whole, you are, giving it a plain meaning, but still there is no sense coming out of the provision. Then the fourth principle comes into play and it says statute to be construed to make it effective and workable. So you will try, you will not just stuck down a statute, you will always try to make sense of that particular statute. And this is the fourth principle which requires the interpretation. So most of the times, whenever there is a confusion, the statute appears to be unworkable. At that point in time, the courts interpret and try to make it effective and workable by interpreting them. Right? I hope I am making sense. One example I can give you of section 89 of Code of Civil Procedure. So section 89 of Code of Civil Procedure had a great challenge in Salem Bar Association case with reference to the judicial interpretation, judicial adjudication and mediation. So it had to interpret and it made the statute workable by giving some interpretation and details about how you should interpret the alternate dispute resolution clauses, which are there in section 89 of CPC. And quite an interesting decision by Justice Ravindran in AFCON's case, right? So refer to that. That will give you a clarity on how statute to be construed to make it effective and workable. Yes, plain here implies a simple meaning, right? So whatever you, after reading that, whether you are, uh, after reading that, whether you are, uh, in plain language, you are able to understand. That is referred to as plain, right? I will talk about it more, Ms. Tiwari, and you will be able to understand it better. Let us move further and talk about another important part, that is everything. This is also a very important reason for having interpretation, that everything is not black and white in law. There is always a twilight zone which needs interpretation and construction. I can give you one simple example of definition of day, that when your day ends and night starts. Now you may be asking that why this question is important. This question is important. Particularly, I will tell you two legislation in which this question becomes important. New labor codes have permitted now women to work after sunset also. And day and night provisions are important from that perspective, because there is a provision which says that if you are employing a woman at night, then there is a requirement of special provisions to be given to them. Secondly, there is a provision under Indian Penal Code which talks about arrest, CRPC, that is Code of Criminal Procedure, or nowadays Bharatiya Nagrik Suraksha Sanhita. So in India, women cannot be arrested after sunset or before sunrise unless there are exceptional circumstances. This is specifically stated in section 46(4). Now there is something which is referred to as twilight zone, right? So this is the twilight zone which requires interpretation. So when do you say that there is a sunset or there is a sunrise, whether it is by way of a clock or it is by way of a, darkness? What is the parameter on the basis of which you will decide? So if you see, in Supreme Court laid down the guidelines in Sheila Barse versus State of Maharashtra, year 1983, the guidelines as to police should follow while arresting a woman. So they should not be arrested at night. And there are multiple rulings by court on this particular aspect. So I hope this you have understood this context of twilight zone that requires interpretation by courts in most of the legal provisions, where one side is saying something, another side is saying something. The court has to come up with interpretation which is suitable, which actually intention of the legislature is, the plain meaning is, all these things applying, the court will be coming up with a finding finally. So this requires interpretation. I hope this makes sense to you. Now we are moving ahead with the basic principles. Okay. Let me see if there are any questions. Okay. Yeah. Right. Now let us move ahead with basic principles 1. And the basic principle says intention of the legislature. What do you mean by intention of the legislature? So when I say intention of the legislature, we are referring to the purpose, or you can say intention with which the legislation came up. Okay. There are plenty of legislation which comes up every year, and every legislation has something to do. And when that particular law comes up, the legislature which makes this particular law has some intention behind that. So whenever the courts have to interpret a law, they have to find out the mens or centennia legis, or that is the intention or the intention of the legislature. Okay. So to find out the true meaning of a provision, you have to go back, see what legislature intended in coming up with that legislation. So it is founded on the premise that every law enacted by the legislature has a purpose, and interpreting the statute in alignment with that purpose is essential for justice and effective government. Now, in intention of the legislature, it refers to objective or purpose the legislative body sought to achieve when enacting a particular statute. It is the guiding principle for interpreting statutes to ensure their application aligns with the legislative will. Lord Denning, he was a very famous jurist, has authored a number of books, and he is also known for his wit. So he said in one of the courts, and he said, while he was explaining why interpretation is important, and he said that it is not within human powers to foresee the manifold set of facts which may arise, and that even if it were, it is not possible to provide for them in terms of free from all ambiguity. So he is trying to say that even if you would have contemplated everything, there may be some facts which may arise, and you will require interpretation of the law in that set of facts, right? So, here, the English language is not an instrument of mathematical precision. It is not mathematics that 1 plus 1 is equal to 2. In law, 1 plus 1 is maybe 3, maybe 4. Depends that what kind of a synergy is coming up, what kind of a context is there. So our literature would be much the poorer if it were. This is where the draftsmen of acts and parliaments have often been unfairly criticized. A judge, believing himself to be fettered by the supposed rule that he must look to the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some or the other ambiguity. Many a times you will find courts have been lamenting upon the legislator, saying that you have not drafted the law properly. There are a lot of problems there. It would certainly save the judges trouble if the acts of the parliament were drafted with divine prescience and perfect clarity. In absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. Okay? He must set to work on the constructive task of finding the intention of the parliament, and he must do this not only from the language of the statute, but from but also from the consideration of which social condition which gave it rise to, or mischief, as I told you, that you have to go behind the purpose of forming the legislature. This is what Lord Denning says. I think this particular quotation gives you a number of background or option as to why law has been or interpretation is required for legislation. Let me move further and talk about another important decision, that is Aaron Salmon versus Salmon. Here, the House of Lords said or observed that the intention of legislature is a slippery phrase. Okay. What the legislature intended can be legitimately ascertained from that which it has chosen to enact, either in express words or by reasonable and necessary implication. So the construction which furthers the purpose or object of an enactment is described as purposive construction. So there are two kinds of construction or interpretation. One is called literal interpretation or literal construction. Another is called purposive construction. Whenever you say literal construction, you are referring to which kind of interpretation? You are referring to the grammatical kind of interpretation. And when you are going ahead with purposive construction, you are referring to logical interpretation, logical conclusion. So a purposive construction of an enactment is one which gives effect to the legislative purpose by following the literal meaning of the enactment, where that meaning is in accordance with the legislative purpose, or applying a strained meaning where the literal meaning is not in accordance with the legislative purpose. This is what has been said in one of the cases by Dr. Jayashree Lakshman Rao Patil. You don't have to remember these cases, but I have provided that for your reference. If you want to read the case law in detail, you can go to that particular cases. So on the aspect of purposive interpretation, we are discussing purposive interpretation. That means what is the purpose of the legislation? And this is in the context of going into the intention of the legislature. What is the intention of the legislature? So if we see purposive interpretation, it says we find that for deciding the present issue, this is with reference to demonetization case. You all must be knowing about demonetization, right? So there was a constitution bench which looked at the demonetization, and that is Vivek Narayan Sharma versus Union of India. And in this particular case, there was, give me a second. Okay. Yes. So I was discussing about the Vivek Narayan Sharma versus Union of India case, and this is a very interesting case that is called demonetization case. So when I say demonetization, demonetization is basically dealing with the cancellation of you can say the um, what should I say, the cancellation of the currency notes, 500 and 1000. You remember that, right? So the purposive interpretation, when I say, we find that for deciding the present issue, it will also be necessary to refer an important principle of interpretation of statutes, that is purposive interpretation. So in this case, the court applied the purposive interpretation. Here, the majority in this particular case applied purposive interpretation, and minority in this particular case, that is by Justice Nagaratna, wanted to apply a literal interpretation. So it said that the law requires that the proposal for demonetization shall move from RBI, and then central government should look at it, and then decision should be done. Whereas the process which was followed was, not exactly that. And hence this was questioned as not proper. And Justice Nagaratna said that, okay, fine, this is not correct. Whereas the majority, and which was authored by Justice B.R. Gavai, he said that, it's okay, the RBI has recommended and the government has notified, and there is a joint exercise. There is no need for one step after another step after another step. If there is a joint exercise between RBI and the government, that is perfectly all right for this situation. And in para 139, it said, our own court has generally taken the view that ascertainment of legislative intent is the basic rule of statutory construction, and that a rule of construction should be preferred which advances the purpose and object of the legislation, and that though a construction, according to the plain language, should ordinarily be adopted, such a construction should not be adopted where it leads to anomalies, injustices, or absurdities. So court has referred to so many decisions, as you can see here in this particular slide, to utilize purposive interpretation in this particular case. Quite an interesting case, and I think everybody would remember this case very well, right? So this is what is the interpretation in this particular case, that is applying purposive interpretation in demonetization case. Now let us move ahead and talk about another important, jurist, that is Kreyes on legislation. His book is very famous on legislation and interpretation, and in many Supreme Court decisions, this book has been cited. And one of the cases, that is Dr. Jayashree Lakshmi Rao Patil versus Chief Minister 2020 case, the court has referred to the legislation, this particular author, and it has said legislation is always to be understood first in accordance with its plain meaning. So it is trying to explain that how interpretation should be done. Okay. And it has given 5-point formula here. So Kreyes on legislation gives 5-point formula. And what is this formula? This formula is saying this formula is basically saying that first you go ahead with understanding the legislation in its plain meaning. If you are getting meaning in the plain, you don't have to go into the details, much details of it, and don't have to manufacture interpretation. Second, it says, where the plain meaning is in doubt, the courts will start the process of construction by attempting to discover from the provisions enacted the broad purpose of the legislation. So first, you will read plainly. If you are able to get the meaning, perfectly, all right. You don't have to go into the purpose. But if there is some confusion this way or that way, then you will go ahead with the broad purpose of the legislation, why the legislation came about. Then, third point, it says, where a particular reading would advance the purpose identified and would do no violence to the plain meaning of the provisions enacted, the courts will be prepared to adopt that particular reading. So there has to be a balance between the literal construction and purposive interpretation. Fourth, it is saying, where a particular reading would advance the purpose identified, but would strain the plain meaning of the provisions enacted, the result will depend on the context and in particular on a balance of clarity of the purpose identified and the degree of strain on language. Now, so you see there are two sides of the pendulum. One side it is saying you look at the plain meaning. Another side is saying you look at the purpose of the legislation. And then it is saying that there should not be too much of a violence on the the letters of the legislation. If you completely change the meaning of the legislation, that is not interpretation, right? So then it is rewriting the law. So you should not rewrite the law. You have to interpret them. If it is possible in the context, in the looking at the purpose, then you should do it. Fifth, it says, where the courts concluded that the underlying purpose of a legislation is insufficiently plain or cannot be advanced without an unacceptable degree of violence to the language used, they will be obligated, however regretfully, in the circumstances of a particular case, to leave it to the legislature the task of extending or modifying the legislation, right? So this is what happens. So if you see many a times constitutionality of a provision is challenged, courts will not change it on its own. Courts will refer the matter to the legislature and say that, okay, fine, this law is not as per the conformity. There is some problem. And they struck down that particular law and it goes back to the parliament again. And the parliament again debates it and then brings up with the legislation. There are several examples of it. One example I can give you, like, for example, the legislation on Tribunal Reforms Act, the recent decision of the Supreme Court on Tribunal Reforms Act. Tribunal Reforms Act has been, brought up by the central government, and the court has interpreted it, and it said that fine, it is not giving the proper meaning as the courts intended to, and hence it is interfering with judiciary. That is what it has said. Not exactly interfering with judiciary, but it has said that it is compromising on the independence of judiciary, and hence this particular law is struck down. So they struck down that particular law. So this is a 5-point formula on interpretation. So you begin with the plain meaning, then you see the broad purpose of the legislation, and then while interpretation, you should see that it is not doing unusual violence to the written words. If you have to completely change the meaning of the written words of the legislation, that is not interpretation. You have to refer back to that legislature, because your job or the court's job is not to rewrite the law. Rewrite the law has the job of the legislature. This is what Reyes says on interpretation. I hope this thing makes it very, very clear to your mind. NGAC Act. Yes, Kuldeep, very well said. NGAC Act is also another example of, you can say the while the court did not want to do any violence in that particular case, and court said that, okay, fine, the law is struck down. Now, This is how it is interpreted. Thank you for that particular example. Now, let me take you further and talk about basic principles number 2. Any question on the basic principle number 1? Any one of you? What is the basic principle number 1? If you can type it in your chat box. Basic principle number 1 of interpretation. Plain meaning. Very good. It is not intention of the legislature, it is the plain meaning. So you have to give plain meaning is the first principle of interpretation. You have to give the, or it is also referred to as literal rule. So you have to give the literal meaning or plain meaning of the statute. Good. Now let us move ahead and talk about the second principle. And that principle is saying that statute must be read as a whole in its context. Now, I think there are questions which you have asked on context. I think now it will be clear to you people, Mr. Veda. So, if you see, what do you mean by statute must be read as a whole in its context? So, it cannot happen that you take only part of the statute which is favoring you and leave the other part. So, statute or law has multiple parts in it. You have definition, you have charging provisions, you have in a provision itself you have proviso, you have exception, you have explanation, you have notwithstanding clause. So you have to read the law as a whole. You cannot say that, okay, fine, I am only concerned with one part of the law, not the other one. I will not read the proviso. That cannot happen. So you have to read the law as a whole. So let us look at it. What does it say? So when a question arises as to the meaning of certain provisions in a statute, it is not only legitimate but proper to read that provision in its context. So when I say the context means the statute as a whole, the previous state of law, the other statutes in pari materia, and general scope of the statute and the mischief that it was intended to remedy. These are referred to as context. Context means surrounding situations. Context means why the law came up. Context means what was the previous law. Context means what remedy this law wanted to provide. Context is what similar situations or similar laws are saying, right? This is referred to as context. Now, Lord Davy talked about this and he said that every clause of a statute should be construed with reference to the context and other clauses of the act so as to, as far as possible, to make a consistent enactment of the whole statute or series of statutes relating to the subject matter. So it is a spoken of construction ex viceribus actus. That is, to ascertain the meaning of a clause in a statute, the court must look at the whole statute, at what precedes and what succeeds, and not merely the clause itself. This is what I was trying to explain you before, right? So it is a better English Lord Davy has written. I was giving you that in a simple language. In case of Tulsi Amma versus Shesha Reddy, that was 1977, court observed it is an elementary rule of construction that no provision of a statute should be construed in isolation, but it should be construed with reference to the context and in the light of other provisions of the statute, so as far as possible to make a consistent enactment of the whole statute, right? So Sinha, Chief Justice of India Sinha, at that point in time in 1963, in State of West Bengal versus Union of India, said that the court must ascertain the intention of the legislature by directing its attention not merely to the clauses to be construed, but to the entire statute. It must compare the clause with the other parts of the law, and the setting in which the clause is to be interpreted occurs. It is also apt to note a few decisions of apex court while regard to interpretation of statutes. This is what courts have said. So context matters. You have to see the surrounding. You have to see in which surrounding the law has come up. What is the objective? How it has formed up, right? So this is referred to as context. Now here the role of judges are very, very important. So the judges do the interpretation. And hence, they have to apply their mind. They have to find out the context, why this particular law has come out, what is the objective. So while examining a particular statute for finding out the legislative intent, it is the attitude of judges in arriving at a solution by striking a balance between the letter and spirit of the statute without acknowledging that they have in any way supplemented the statute would be proper criteria. So the duty of the judge is to expound and not legislate is a fundamental rule. So judge is not there to legislate a legislation. His objective is to expound, to explain the legislation to people. There is no doubt a marginal area. So there is always a marginal area in which courts can creatively interpret legislation, and they are thus the finishers, refiners, and polishers of legislation which come to them in a state requiring varying degree of further processing. So courts can always process the legislation for towards interpretation, and this you have seen in multiple cases where courts have given the interpretation of provisions in one way or the other. By no stretch of imagination, a judge is entitled to add something more than what is there in the statute or intention of the legislature. It is therefore a cardinal principle of construction of statute that true or legal meaning of an enactment is derived by considering the meaning of the words used in the enactment in light of any discernible purpose, object. So this I have already explained you. So judges have to also follow that. Applying the aforesaid principle, we really fail to understand as to how the learned judges of Bombay High Court could come to a conclusion that mismanagement must necessarily mean an element of fraud and dishonesty. This was in the case of one of the cases. That is Dupont Steels versus All India, All England Reporter. So caution is all more necessary in dealing with legislation enacted to give effect to policies that are subject to bitter public and parliamentary controversy. For in controversial matters, there is a room for differences of opinion as to what is expedient and what is just, what is morally justifiable. It is Parliament's opinion in these matters that is paramount. Now, over the years, you must have been observing a number of courts' decisions are becoming, politically grounded, or you can say having political connotations, particularly right now with reference to election commissions. And in the court, there is a lot of discussion happening around that. Courts have always said that you have to do a political battle, go into the political space, not in the courtroom. If you see, one of the Supreme Court judges made this particular remark while hearing a case. So, role of judges are very, very important. Judges have to stick to the legislation. They don't have to see anything around, right? I was hearing Justice Ranjana Desai, former Supreme Court judge, yesterday in one of the functions, and she said that do judges don't read newspaper? They read. Don't they have their idea? They have their idea. Don't they have their own mind? They have their mind. Can they look at TV and news channels? They look at it. But when they are deciding a matter, they don't have to get influenced by any of these. They have to have a look at the provision and interpret the provision as the words says and intention of the legislature. So this is what role of judges are. I just thought that I will tell you the role of judges also, because we are talking about interpretation, and interpretation does not conclude without the role of the judges. You don't have to memorize these judgments, okay? If you recollect some of them, it is well and good. If you don't, then it is okay. Now, let us move ahead and talk about basic principle number 3, right? And this basic principle number 3 says that statute has to be construed to make it effective and workable. So you should always look towards making the law workable rather than scuttling it or deleting it. So the question in one of the cases arose that whether section 28(1) subclause 1 read with 18A(9) of the Act it is competent to the income tax authority to impose a penalty on a person who has failed to comply with section 18A subclause 3 of the Act. So what is the background? Let us look at it. So the legislature enacted 18A(9)(b) of the Income Tax Act, probably it is referring to, to bringing the failure of sending estimates under 18A3 within the operation of section 28, it signally failed to achieve its object. So the construction which leads to such a result must, if that is possible, be avoided on the principle expressed in the maxim. And this maxim you will find is there in your part of your syllabus. At res magis velit quam perit. Okay. So it means it is better for a thing to have effect than to made void. So always you should try to make law applicable rather than making it void. Okay. Hmm. If it cannot be made applicable, that is a different thing altogether. So you will try. If it is not made workable, then ultimately you move ahead and try to get it again legislated. Yes. So the only alternative construction offered to us would lead to this result that the plain intention of the legislature has entirely failed by reason of slight inexactitude in the language of the section. If we were to adopt this construction, we should be construing the act in order to defeat its object rather than its view to carry its object into effect. So if you see, it is basically saying that to be workable and the interpretation thereof by a court should be to secure that object unless crucial omission or clear direction makes that end untenable. So in this case, the court was of the opinion that it was competent to income tax authority to impose penalty under section 28 read with so and so where there has been a failure to comply with 18A subclause 3. So 18A subclause 3 was added that you should give your estimate about the income tax. And if you don't give it, then there is a failure. And income tax authorities can impose a penalty if you are not providing with the estimates. So this is what was held in this case, Commissioner of Income Tax versus S. Teja Singh, 1959 case. So you have to always look at the legislation for making it workable. This is what this provision says. Yeah, legal language is a bit tough. I can understand that. Okay, let us move ahead and talk about this principle, basic principle, that if meaning is plain, effect must be given to it irrespective of the consequences. So if the plain meaning is there, you don't worry about the consequences. You give an effect to that. So it is well settled principle that the statute is an edict of legislature. The conventional way of interpreting or construing the statute is to see the intent of the legislature. So intention of legislature assimilates two aspects. One, that carries the meaning. What does it convey? Purpose, object, reason. And the process of construction therefore combines both liberal and purposive approaches. However, necessity of interpretation would arise only where the language of a statutory provision is ambiguous. If the language is plain, language is simple, language is clear, you don't have to go into the depth of it to find out some different meaning, right? So, in Sussex Peerage case, the court said that the rule of construction of Act of Parliament is that they should be construed according to the intent of the Parliament which passed the Act. If the words of a statute are themselves precise and ambiguous, there is no more can be necessary than to expound those words in the natural and ordinary sense. The words themselves do in such case best declare the intention of the legislature, and you don't have to do anything else. Let us look at one of the interesting cases, and this is basically you all must be knowing about this case. This is Rahul Gandhi's case. There are multiple cases, but this is one of them. And it deals with one of the cases which was filed by one MLA, Purnesh Modi, who filed a criminal defamation case at Surat under section 499, 500 and 504 of Indian Penal Code against Rahul Gandhi. He claimed that Rahul Gandhi's remark defamed the entire Modi community because he had said something in a election speech. And on that, there was a case which was filed before the chief magistrate, judicial magistrate in Surat, and its case was registered. Yes. So in one of the on April 16, 2019, BJP MLA filed the criminal case, and then immediately after his conviction, yeah, so he was convicted in 2023, And he immediately after his conviction, he was disqualified from the parliament. So the Lok Sabha Secretariat issued a notification on March 4, 2023, informing various offices as well as Election Commission of India about his disqualification. So what the law said, the law basically said Representation of People's Act along with 1021E of the Constitution of India stated that any member of parliament on conviction for certain offences which are punished with imprisonment of 2 or more years, they will be vacating the office or they will be having disqualification. So Article 1021E allows the disqualification of a member of parliament in accordance with any law of the country. So this is where you don't have to, because there was a plain meaning irrespective of the consequences. Now the consequences in this was that the right of Mr. Rahul Gandhi was taken away. He was not able to go to the parliament, and he pleaded before the Supreme Court that, see, it is a parliamentarian and he should go. But irrespective of the consequences, the literal meaning of the plain meaning of that particular word or decision was interpreted or brought forward. And this is how the there was no explanation required in this particular case. The law was clear. If there is a punishment more than 2 years, then there is a disqualification, and on this disqualification, the parliament, or you can say the Lok Sabha, acted. So this is an example of plain meaning. Another example I can give you is of M.V. Joshi versus M.U. Shimpi and others. So this was a case where the appellant M.V. Joshi was a butter dealer and he was convicted for selling butter that was below the prescribed standards. Okay. So the question here was whether the butter prepared from curd falls within the definition of butter as stipulated by relevant rules, and consequently whether selling such butter constitutes an offense under the Act. So herein the argument of Mr. M.V. Joshi was that, okay, I am not making Amul butter, or I am not making butter by processing and all. I am preparing butter by processed curd. So the court said that, in this particular case, food inspector seized butter from M.V. Joshi's shop, which upon analysis was found to contain 18.32 foreign fat and so milk fat, thereby failing to meet the prescribed standards of rule number so and so. So the judicial magistrate initially acquitted Joshi, arguing that butter prepared from curd did not fit the legal definition of butter. However, the High Court overturned this acquittal, asserting that butter prepared from curd is indeed covered by the definition and selling butter below the prescribed standard qualifies as selling adulterated food. The Supreme Court upheld the High Court's decision, adjusting the sentence from rigorous imprisonment to fine, thereby reinforcing the interpretation that butter made from curd is subject to same standards as butter made directly from the milk or cream. So here the fundamental principle of interpretation is that, namely, the primary test is language employed in the Act, and when words are clear and plain, the court is bound to accept the expressed intention of the legislature. I hope this gives you clarity on interpretation of statutes, right? So this is one of the cases. Similarly, there are a number of cases, on which you will find, particularly with reference to certain materials, in case of income tax, in case of customs, you will see that the definition of a term, like for example, whether paratha is a roti, paratha and roti are same things, or whether chocolate and mithai are same thing. These are different interpretations, and you can see for taxation purposes particularly are categorized into different elements. You would have seen this particular discussion with reference to popcorns, right? Caramel popcorn and normal popcorn taxation are GST rates. And similarly, AC restaurants and normal restaurants, the rates of samosa can vary because it depends on the context. So you have to see these taxation legislation require very, very strict interpretation, irrespective of the consequences which follow. So, dear students, I think we have come here at our break time. I think we have exceeded that particular time. It is already 7:20 now. So we will take a 15 minutes break and we will reassemble at 7:35. So looking forward to see you at 7:35, all of you, and you can have your questions ready. We can answer some of the questions, more questions when we assemble. Okay. 7:35 we meet again. move ahead with our class. But before I move ahead with the class, let us have a quick recap. And if you can tell me which are the four principles which we have talked about, four basic principles of interpretation. If you can put it in the chat box, then we can proceed. Which are the four principles which we talked about on interpretation, the basic interpretation principles before we move ahead with rules of interpretation and construction? So any input you can give? In the meantime, I'm looking at the questions or queries. One of the queries by Ms. Tiwari is that whether there is a scope of referring to authors for interpretation of statutes. Yes. So the courts have referred to the authors of interpretation of statutes in many situations, as I quoted before, like Craig on interpretation, or maybe GP Singh on interpretation, or maybe other author on interpretation, because these authors are original authors and they have given their view on how to interpret legislation, and the courts have taken reliance to these, and these are all external aid to interpretation. Okay, so authors' interpretation are external aid to interpretation. We will talk about it in our next session probably. Today we are talking about basic principles and primary and secondary rules of interpretation. Okay, any other questions? Okay. Yes, rule of literal construction means giving plain meaning to the law. Yes. What are the four basic principles which we talk about? Yeah. One of them is rule of literal construction, that is giving intention of the legislature. Very, very, very good, Ms. Jose. What else? Read as a whole and meaning plain effect must be given. We will make it workable statute. Very well. So these are the four things. Okay. So Mrs. Steffi Jose puts it very, very clearly. Intention of the legislature. Read the statute as a whole. Meaning must be given plain effect or plain meaning, and you should try to make that legislation workable. That is, these are the four basic principles which has to be there. Rule of reasonable construction, yes. Harmonious construction, yes. To make the statute workable, yes. So you begin with literal rule and you go ahead with harmonious construction as well. Okay, with these, let us move ahead and talk about our rules of interpretation and construction. So you can see there are primary rules and there are secondary rules. So the primary rules are listed in your course material as rule of literal construction, rule of reasonable construction, rule of harmonious construction, rule in Hayden's case or mischief rule, rule of beneficial construction, rule of exceptional construction, and rule of ejusdem generis. These are the primary rules. And in secondary rules, they have talked about doctrine of nocere soci and doctrine of contemporanea expositio. So we will talk about these rules one by one with some examples also, so that it becomes clearer to you. But I must tell you that these rules are also not written in any legislation. These rules have come up by way of interpretation of the courts, and hence these are case laws which actually establishes these particular rules. So we will move ahead and talk about these rules one by one. So the first rule is rule of literal construction, and this we have seen in our primary rules also, right? So you begin with the literal, literal interpretation of the law. So the literal rule, also known as the plain meaning rule, is type of statutory construction which dictates the statutes are to be interpreted using the ordinary meaning of the language of the statute, unless a statute explicitly defines some of its terms otherwise. So for this, you have to see the plain meaning of the words. However, in many legislation, you will find a definition clause. So definition clause may provide for a different meaning. So in that situation, you need to read that particular meaning accordingly. In other words, the law is to be read word for word and should not divert from its true meaning. It is the mechanism that underlines textualism and to an extent originalism. So this is also referred to as originalism. So there is a Latin maxim which is called absoluta sentenia expositor non indiget. Literally, it means an absolute sentence or preposition needs not an expositor. In other words, plain words require no explanation. So if plain words are there, There is no requirement of an explanation. Thus, it is primary duty of the court to interpret the words used in legislation according to their ordinary grammatical meaning in absence of any ambiguity or doubt. So in Principles of Statutory Interpretation by G.P. Singh, it is said the intention of the legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said as also to what has not been said. As a consequence, a construction which requires for its support addition or substitution of words or which result in rejection of words as meaningless has to be avoided. So you should not try to find an interpretation wherein you have to add some words or reduce some words or delete some words. You have to give meaning to each of the words which are there in the statute, right? Making sense? Now let us move ahead and talk about more of it. So it says, language of the statute should be read as it is. So you have to avoid any addition or substitution of the words. Let us take an example. In British India General Insurance Company versus Captain Itbar Singh, this was 1959 case. The question was, what is the scope of defenses available to insurers under Section 96 subclause 2 of Motor Vehicles Act? The court in this case held that insurers cannot challenge the quantum of compensation awarded unless they prove one of the grounds specified under Section 96(2) of the Motor Vehicles Act. No additional ground may be added by inserting the word also after the words on any of the following grounds. So if you see the statute, it goes like this, and it says to defend an action on any of the grounds, namely. So it has listed particular grounds on which the insurer can challenge the compensation awarded. So you cannot add any more grounds to it. It is a very, very clear list which has been provided. It is not, you remember means and includes definition. So it is not using the word includes. It is not it is basically trying to say it is means, or in fact, it goes beyond means and it says namely. So it has given specific past aspects. So the court reinforced the doctrine that no word should be added or omitted in interpreting statutory text unless absolutely necessary to avoid absurdity or inconsistency. So this example gives us the understanding that you should not add any words or reduce any words while interpreting a legislation. Let us look at another example, and this is about the term called causus omissus. So when I say causus omissus, so causus omissus is basically providing the missing words in the legislation. So this was laid in one of the cases of Gladstone versus Bower in 1960. And here the principle of equitable estoppel and the requirement of clarity in contractual terms was the issue. So it emphasized the importance of interpreting contractual terms based on their plain meaning without assuming additions or substitutions. So the court held that no words or obligations can be implied into a contract unless it is necessary to give business efficacy to the agreement. The principle applied was that the parties must abide strictly by the words of the contract unless those words lead to an absurdity or fail to achieve the clear intention of both parties. So you remember in my initial slide, we distinguish between three terms. One is the statute, deeds, and documents. So this is talking about interpretation of deeds, right? This example. So if you see here, it is saying that you should not provide anything which is not there. So the case underscores basically 2 points. The first, the literal rule of construction requires interpreting a statute or contract exactly as written. And secondly, the court should not modify contracts by inserting or omitting terms except in circumstances where the omissions makes the contract unworkable or leads to absurd outcomes. So your fourth, basic principle, which was that you have to make the statute workable, that is what it is trying to tell you. Here, I would like to also, refer to one of the infamous cases of Rogers versus Alliant, wherein the contract, there was a termination clause was challenged on the basis of a comma. Now I leave this particular case for your exploration. So this is today's homework. On Wednesday, when I discuss with you, we will talk about this particular case in a bit detail. Okay. So you can search for this case, quite an interesting case, wherein there was a contract, and on the basis of the interpretation of a comma, this particular case was decided. So you can see how important the comma also can be in a contract. Okay. So please go through this particular case as an assignment, and we will talk about that in my next class. Now, look at another case. There's Bangalore Water Supply versus Sewage Board. Here, the case involved the interpretation of the term industry under the Industrial Disputes Act 1947. So, the court extended the statute's scope by interpreting the term industry expansively while acknowledging the omission. So, in this case, there was an expansive definition of industry which was provided. And I think labor law, complete jurisprudence rests on this Bangalore Water Supply case on the definition of industry. So this is about causes omissions. So causes omissions basic principle is court should not provide for the words which are missing unless there is a requirement of making the statute workable. Then there is one more important principle which says avoiding rejection of words. So every word in a statute is assumed to have been deliberately included by the legislature. So courts should strive to give meaning and effect to all words, avoiding interpretations that render any word or phrase superfluous or redundant. So, in case of State of Bombay versus Ali Gulshan, the clause A of subsection 4 of section 6, where discussing omitting portions unnecessary for our present purposes, runs in these terms. So, here it said the state government may, by order in writing, requisition the premises for the purposes of a state or any other public purpose, and may use to deal with the premises for any such purpose as may be appear to expedient. Beyond be no doubt, state went ahead and tried to interpret this, and they gave the definition and said that whether the public purpose will include housing a member of the staff of a foreign consulate, the court interpreted, and it went ahead and dealt with the concept of public purpose, and it said an undertaking may have three different facets or aspects and may serve for purpose of the state. And it went ahead, and courts should lean against the construction which would render the words in a statute as mere surplusage. So you should read the statute in a way that it is not left mere surplusage. It is, you have to have a understanding, of the statute in a way that does not omit the meaning of a word. That is what it is trying to tell. Let me see. I have some inputs here. Okay. Yes. Yes, Latin maxim is required, Meenakshi. So I have seen some of your questions in the earlier phases. Some of the Latin maxim which appears in your course material, you need to cover that. Okay. You need to know the meaning of that, because there may be a question on explaining a Latin maxim. So you have to give the answer to that. Okay. Now let us move ahead and talk about the another jurist. And so here again we find a jurist. Okay. So this is Cross. He has also written a number of books on interpretation. One of the statutory interpretation book is very famous by Cross. So what Cross says? Cross in statutory interpretation states that the governing idea here is that if statutory provision is unintelligible in the context of ordinary language, it ought without more to be interpreted in accordance with the meaning an ordinary speaker of the language would ascribe to it as its obvious meaning, unless it is sufficient reason for different interpretation. So there is something which in law we call it standard of a common man or a common person. Nowadays we use the word person. Man is now gender sensitive, so we use person. So we are talking about common person. What this word would mean to a common person rather than a person who is experienced in law, right? So he's talking about that. So that when you are giving a literal meaning to the words, you should look it from the perspective of a common person rather than anybody else. So thus, an ordinary meaning or grammatical meaning does not imply that the judge attributes a meaning to the word of a statute independently of their context or for the purpose of the statute, but rather that he adopts a meaning which is appropriate in relation to the immediately obvious and unsearched context and purpose and for which they are used. So, by enabling citizens and their advisors to rely on ordinary meanings, unless notice is given to the contrary, the legislature contributes to legal certainty and predictability for citizens to greater transparency in its own decisions, both of which are important values in a democratic society. Lord Reed, in one of the cases, said, in determining the meaning of any word or phrase in a statute, ask for the natural or ordinary meaning of that word or phrase in its context in the statute and follow the same unless that meaning leads to some result which cannot reasonably be supposed to have been legislative intent. Rules of construction are our servants and not masters. This is a very important line which says that construction doesn't drive you. You drive construction, right? So interpretation does not drive you. You drive interpretation. So hence, you have to make sense of the legislation, and statutory provision cannot be assigned a meaning which it cannot reasonably bear. If more than one meaning are capable, you can choose one, but beyond that, you must not. This is what Lord Reed said in one of the cases. So that was literal rule. Any question on literal rule? I hope literal rule is clear. Well, Aditya, I have been told that you should avoid any political comments or this in your answers. So I would suggest you talk about cases which are neutral in nature. Okay. Right, Aditya? Okay. Let us talk about the other one. Any question on the literal rule? Any one of you? If there are any questions on literal rule, I will entertain. Otherwise, we'll move ahead. Ascribe. Ascribe means to impute, or you can say uh, to impute or to refer to or to associate. That is what ascribe means. Yes. Okay. Now let me move further and talk about the golden rule of interpretation, or you can say this rule is also referred to as rule of reasonable construction. So most of the time you will go ahead with literal rule, but golden rule of interpretation is the legal interpretation principle, which allows court to modify the meaning of law to avoid absurd outcomes. So there may be a situation where outcomes are absurd. In that situation, it gives flexibility to the courts to give true meaning to it. So it is used when literal meaning of a law is clear, but leads to an unreasonable or unjust result. So the words of a statute must be construed ad res magis velet quamperit, meaning that the words of the statute must be construed so as to lead to sensible meaning. This that is grammatically. I will give you an example. And this is a quite an interesting example. So you can see here figure, there's a light blue, there is a dark blue, and dark blue is the RAF station, and this A is the person. Okay. Let us look at it. This is a famous case of Alder versus George, 1964. And this is an English public law case that exemplifies the application of golden rule of statutory interpretation. So you can see here, this was a case which involved the interpretation of Section 3 of the Official Secrets Act of 1920. In India also, we still apply this Official Secrets Act. According to the Act, it was an offense to obstruct Her Majesty's forces in the vicinity of a prohibited place. So here, The question defend is on the term in the vicinity of the prohibited place, and in particular, interpretation of the term vicinity. So here the defendant, that is A, entered the RAF station, a prohibited place under the Act. He entered the RAF station, but he made an argument and he said that he was not in the vicinity of the station as required by the literal reading of the statute. The key issue was whether the defendant, by entering the RAF station, violated the terms of the Act, given the literal interpretation of the term in the vicinity. And what is the meaning of the word in vicinity? Vicinity is nearby, aspas. Lekin wahan nahi. So this is what it was trying to tell. When you are saying he was in the RAF station and not in the vicinity of the station, and that is what was his argument. Quite an interesting argument, right? So I often find my students, arguing like that whenever we have a situation at our university. So in the High Court, the defendant conviction was upheld under the golden rule of statutory interpretation. The court applied the golden rule to avoid an absurd outcome. You say, for example, they would not have applied. They would have applied the literal rule. So a person A in the dark blue region would have not committed the violation, while away from the RAF station in the vicinity, they would have committed the violation. So this was quite an interesting one. So Lord Parker CJ emphasized in this case that the potential absurdity in strictly adhering to literal rule. He stated that it would be extraordinary and absurd if an indictable offense was created when obstruction occurred just outside the precincts of the station, but in the vicinity. On the other hand, no offense would be created if the obstruction occurred directly on the station itself. The judges used the golden rule, allowed for a more reasonable interpretation that aligned with the broader purpose of the statute. So I hope you are able to get the clarity on this golden rule of interpretation. Then there is another rule of interpretation, that is rule of harmonious construction. So this rule is applied when there is a conflict between two provisions of a statute. So similarly, this rule also comes to our aid when there is a conflict between provisions of a statute and object which the legislature had in view. So if you see this particular statute, many a times we are posed with a situation of harmonious construction between environmental regulation versus economic development. This situation arises many a times. So if one law protects the environment while the other encourages economic development in the same area, the court can use harmonious construction to balance the two laws. If you will see under the Constitution, Part 3 and Part 4 of the Constitution, Supreme Court has many a times applied the harmonious construction. They have tried to interpret both Part 3 and Part 4. Part 3 of the Constitution talks about fundamental rights. Part 4 talks about directive principles of state policy. And one is enforceable, another is non-enforceable. But even in case of non-enforceable directive principles, courts have applied harmonious construction. And that is how you are able to see some rights being converted into fundamental rights, like, for example, right to education. Article 21A was included later on by interpretation of the directive principles. So if you see, this is what has happened. There are multiple cases in which similar kind of decisions have been given, like, for example, Goa mining case, Mopa airport case, Sterlite copper plant case, sand mining cases, NCR construction ban case. These are all cases courts have discussed environmental regulation versus economic development and tried to balance the situation. So it is a basic rule of interpretation that if it is possible to avoid a conflict between two provisions on a proper construction thereof, then it is duty of the court to construe them and that they are in harmony with each other. A specific rule will override a general. This principle is acceptable. Move ahead. Court in the case of Commissioner of Income Tax versus Hindustan bulk carriers. So in this case, the court has given principle of doctrine of harmonious construction, and in detail it has explained that how do you go ahead with harmonious construction. So it lays down the following steps, and it says, while interpreting the provisions, the courts need to avoid all circumstances of head-on clash between the provisions. They must be construed harmoniously. Okay, this is one point. Second is interpretation by the courts should be done in such a way that one provision does not defeat the other provision unless there seems to be no possible construction. If the situation is so that it becomes impossible to reconcile the provisions in conflict, the courts must decide in such a way that both provisions are given effect to. Any construction that renders one provision of the statute or another statute in the case of two different statutes, unless the dead letter should not be given effect, such construction is not a harmonious construction. Harmonious construction is one which does not defeat any provisions, any other provisions. Similarly, in Kerala Education Bill, the Supreme Court held that deciding the fundamental rights, the court must consider the director principles. I have given you example of director principles in a harmonious construction. So two possibilities are given effect as much as possible by striking a balance. This is what is harmonious construction, right? Somebody has raised the hand. Can we permit the person if they have to ask a question? Any one of you? I think it was... yeah. Khushbu, you have any question? You can type your question in the chat box if you can. That will be more easier and to deal with it faster. In the meantime, I continue. You type your question there, okay? We will permit you to speak towards the end once we complete it. Now, let us look at this provision of subject and object. So many a times when you are going ahead with the interpretation, you look at the subject and object of that particular legislation, right? For example, in UP Bhudan Yagya case in 1988, in the context of UP Bhudan Yagya, the Supreme Court emphasized that landless persons eligible for redistribution of land must meet specific criteria as defined in the Act. It held that mere lack of formal land ownership was not enough. Landless person should also demonstrate an economic need of the land consistent with the welfare objectives of the statute. Similarly, like say, for example, this one is dealing with one nation, one election provision, statement of objects and reasons. You can see a detailed objects and reasons has been given that why you require one nation, one election. There is a lot of debate happening around one nation, one election. I think you people must be also aware about it. So Ramnath Kovind, under the chairmanship of Sri Ramnath Kovind, our president of India, former president of India, submitted a detailed report that why one nation, one election is important for the country and what are the reasons. So you can see there are different reasons which are given in statement of objects and reasons. So this is also instrumental or important for interpreting the provisions of the law. So this is what is there. Now, let us go ahead and talk about some of the other provisions which are interesting one. And it talks about the provisions, right? Now, let us move ahead and talk about the terms. Many a times you will find the word like subject to, notwithstanding, without prejudice. So these terms will be appearing many a times in your legislation. And everything has got a meaning. So in interpretation, we refer to them in a particular way. So in some cases, the statute may give a clear indication as to which provision is subservient or which overrides. So there are certain provisions which are lesser important and there are certain provisions which are more important. So when I say subservient, that means lesser important. When I say overrides, that means it is a more important. So this is done by the use of the term subject to, notwithstanding, or without prejudice. So the impact of words subject to when used in a provision is that when the same subject matter is covered by that provision and by any other provision or enactment subject to which it operates, then there is a conflict between them, then the latter will prevail over the former. Let me give you an example. Section 13(2) of the Companies Act talks about any change in the name of the company shall be subject to the provisions of subsection 2, 3 of section 4 and shall not have effect except with the approval of the central government in writing. So it is saying changing the name of the company is permitted, but it is subject to what? Meeting the section 4 subclause 2 and 3 provisions. That is under the memorandum of association, name clause and registered office clause. That is something which it has to meet, right? So this is what it is subject to. Then there is a word which is called without prejudice. So if you see without prejudice, it says when certain particular provision follow general provisions. And when it is stated that the particular provisions are without prejudice to those general provisions, the particular provisions would not restrict or circumscribe the operation with respect to the general provisions, right? So general provisions very much stay without prejudice to that particular provisions. I am making a particular statement. So this is called without prejudice. So without prejudice to your course material, which has been given to you, I am teaching you some additional material in this particular slide. What does it mean? That it is not overriding your course material, but it is supplementing the course material. I hope this example gives you clarity in terms of without prejudice application. Then comes notwithstanding. This is a very famous clause in legislations, that is notwithstanding, or we also refer to as non-obstante clause. So non-obstante clause is a clause which begins with the word notwithstanding anything contained, is called the non-obstante clause. So unlike the subject to clause, which we saw in the beginning, the notwithstanding clause has the effect of making the provision prevail over others. So if you see wherever you find notwithstanding, that means after whatever notwithstanding comes will prevail over the other provisions mentioned there. So this is, let us have a look at this example, and this is an important provision. There are 4 levels of notwithstanding, and this is given in your coursework also. So if you see, the first level of notwithstanding is notwithstanding anything contained in any other section or subsection of that statute. So it is saying only with reference to that particular subsection or section of a statute. So I have already given you a detailed analysis of what does the statute contains, right? So statute has multiple sections: preamble, sections, subsections, schedule, explanation, all those particular things are there. So it is saying that notwithstanding in that section or subsection of that particular statute. So it is limited, right? So this clause will override such sections or subsection. There may be notwithstanding clause where it says anything contained in a statute, notwithstanding anything contained in a statute. So it is referring to whole enactment. So the clause will override the entire enactment. And this you find it in section 8(8) of the Companies Act, and it says amalgamated with another company registered under this section and having similar object, then notwithstanding anything to the contrary contained in this act, the central government may by order provide for the amalgamation. So it is section 8(8) is saying that amalgamation cannot happen. But then it says, notwithstanding anything contrary contained in this particular act, central government will have power to issue a direction for that particular kind of a amalgamation. Third point is notwithstanding anything contained in specific sections or subsections of all the provisions contained in another statute. So it may refer to another statute, and the clause will prevail over the other enactment. Like, for example, many a times whenever a new legislation comes up, these kind of notwithstanding is there for removing the older legislation. Like, for example, section 7A of the Securities Contract Act 1956, it said, and on such publication, the rules as approved by the central government shall be deemed to have been validly made, notwithstanding anything contained in the Companies Act 1956, right? So it is referring to Companies Act while in the Securities Contract Regulation Act. So it overpowers Companies Act. So I hope this gives you clarity. Then fourth one says, notwithstanding anything contained in any other law for the time being in force. The clause will cover all others. So it is not specific. Nowadays, generally you will find is the fourth level. Right? Then it begins within the statute, then it begins with one statute, and then it begins with all statute to the exclusion. I hope this gives you a clarity on this. Now we are moving ahead with another important rule. But before I move to that particular rule, if there are any questions, you can use the chat box if there are any questions. Enactment and law, Kuldeep, are the same things. There are no difference between them. When you say enactment, it is law. These are two different terms used for the same thing. Okay, let me proceed with the other rule. So this rule is rule in Hayden's case, we call it, or we call it mischief rule. One of the most famous rules in interpretation. So this Hayden's case is of 1584. And this case involved basically a leases, life estates and statutes. So there was a Ottery college which granted a tenancy in manner to where the father and where the son. These are the two people, where the father and where the son. To it was granted a tenancy. So this tenancy established by copyhold was subject to the Lord's will and the manor's customs. Now the same parcel was later leased to Hayden for 80 years. So the Ottery College also leased this particular thing to Hayden for 80 years. Now Parliament came up with a law that Separation of Religious Houses Act, and it dissolved all religious colleges. So Ottery College was also dissolved. However, the act protected the grants made over a year before its enactment. So if you see, the Court of Exchequer found the grants to the wares protected but declared Hayden's lease void, because Hayden's lease was given within 1 year, and the tenancy which was given by Ottery College to Ware was much prior. So the court looked at the mischief and it said that you cannot transfer your rights to somebody else. So generally what happened is, the Separation of Religious Houses Act actually meant that all these particular colleges who have been given property should be taken away. And to circumvent that particular provision, Ottery College wanted this to be leased to Hayden rather than tenancy which was given to Ware and father and Ware the son. So the court interpreted this provision and it tried to lay down the rule of mischief rule. So our court in this particular case describes for the sure and true interpretation of the penal official restrictive, what was the mischief and defect for which the common law did not provide. Third, you say what was the remedy the parliament tried to resolve or introduce or appoint or cure the disease of commonwealth, and last, the true reason of the remedy. And then the office of all the judges is always to make such construction as shall suppress the mischief and advance the remedy, and to suppress subtle inventions, evasions, or continuance of mischief, and pro privato commodo, and to add force to the life of the cure of remedy according to true intent of the makers of the act pro bono publico. So this is a quite an interesting statement. It is saying that you have to look at the interpretation which is promoting public interest and not private interest. So in this particular case, court and that Separation of Religious Houses Act came up with the objective to release the leases and grants which were given to religious endowments for public purposes. And now if you here in this particular case, if you permit that particular tenancy to Hayden, then you are promoting private interest, not the public interest, and hence the court held otherwise. So it is basically quite an interesting decision. Now also this mischief rule is getting interpreted at multiple places. So there is another example. Example number 6 in your, I think in your material. Application for this mischief rule is also well founded in the construction of section 2D of the Price Competition Acts. So the section defines price competition as any competition in which prizes are offered for the solution of any puzzle based upon the building up of arrangement, combination, or permutation of letters, words, or figures. So the issue was whether the act applies to competitions which involve substantial skill and are not in nature of gambling. So the Supreme Court, after referring to the previous state of law, to the mischief that continued under that law, and to the resolutions of various states under Article 252(1), authorizing Parliament to pass the act, has stated as follows. It said, having regard to the history of legislation, the declared object thereof, and the wording of the statute, we are of the opinion that the competitions which are sought to be controlled and regulated by the act are only those competitions in which success does not depend on any substantial degree of skill. So this is what was the interpretation. So it tried to look at the mischief. In another case, that is Kannilal Paramnidhi, the Supreme Court held that the observations made by the Chief Baron and Barons of Exchequer in Haddon's case have been so frequently cited with approval by the courts administering provisions of welfare enactments that they have now attained the status of a classic. So this is what they have said, but mischief rule can be applied only if there is an ambiguity in the present law, not otherwise. However, there is a critique to this mischief rule, and this is the US perspective. So I think I will park this particular slide for maybe in the next session, because there's too much of a discussion on this. However, I will share this slide. You read this particular slide. I gave you another assignment was relating to that comma case. So you should read about comma case, as well as you should read about this critique on US perspective. We will touch upon them on Wednesday. Now, there is a rule of beneficial construction. This is also another rule which is there in the law. And it says not a rule, but it is kind of a interpretation tool, an interpretation way of interpretation. And it says that the provision should be interpreted literally to give effect to its nature. And this is also referred to as beneficial is actively possible, and not when the words in the statute are quite unequivocal. Okay. So when you can give the benefit, when there are two constructions, A and B possible, and B is more favorable to one person, you can extend B to that. But you cannot, create a construction B if there is no construction there, right? So plain meaning things should be always remembered. But if there are two meanings and one of the meaning is benefiting another person, in case of beneficial construction, you can give that benefit. Like, for example, in the case of Alembic Chemical versus Workmen, an industrial tribunal awarded more number of paid leaves to worker than what was mentioned in 79(1) of the Factories Act. This was challenged by appellant. Supreme Court held that enactment being welfare legislation for the workers, it has to be beneficially constructed in the favor of the workers. And thus, if the words are capable of two meaning, the one who gives benefit to the workers should be used, right? I hope this makes sense. Another case, Tolaram versus State of Bombay, the court observed it is well settled rule of construction or penal statutes that if two possible and reasonable constructions can be put upon a penal provision, the court must lean towards that construction which exempts the subject from penalty rather than the one which imposes a penalty. So Article 21 of the Constitution of India, for example, is a provision where there is a beneficial construction given many a times. It says no person shall be deprived of his life and personal liberty except according to the procedure established by law. And you can see this provision has been interpreted to enlarge the scope of Article 21, and this has been dealt with by the Supreme Court. And there are a number of rights which have been included in Article 21 by way of this liberal construction, or you can say beneficial construction of the statute. Then there is rule of exceptional construction, or you can say exceptional construction is kind of a principle of statutory interpretation that is used to interpret statutes in a way that deviates from the usual rules of interpretation. So this principle is used when the usual rules of interpretation, such as plain meaning rule or mischief rule, will lead to unjust or unreasonable results. Right? So you remember the maxim, "Ut res magis velet quam perit," that is, it is better for a thing to have effect than to perish, that the matter may have effect rather than fail. So this is what is or you can say the fourth principle which I dealt with you is that the statute should be made workable. Right? So you remember that particular provision? Statute should be made workable. Now, let us have a look at this part, and there is an example. Maharaj Singh versus State of UP, 1976, AIR 2602. An exception to the same word, same meaning principle was made regarding the interpretation of the word West as the used in UP Zamindari abolition and of the Zamindar for local Zamindar. But when it was to come from state to Gram Sabha, it was not full ownership, only for governance and public use. So you can see at two places where the different meaning has been ascribed to the word West. So friends, I think we have completed our session today. Any questions if you have, I will be happy to answer. Let me see. There are a couple of points which are there in your chat box. Okay, notwithstanding, I will repeat again in my next class, Aditya. There are 4 notwithstanding clauses which are there. So I would suggest you read a bit of your course material on that, and then it will be more clearer. Because see, interpretation is a topic or a subject which will require you to read again and again. And if you read more, then you will be able to understand it better. Okay. Sections, Bala Murugan, on sections and this provisions and this, you can remember it only with mapping it. This is a basically general learning tool which we utilize, that you have to relate those particular things with some things of your daily life. So if you make that particular linkages, you will be able to remember or relate. So most of the times, that is why we make the case laws or things related to certain things, or some story or some person. So then you will be in a situation to remember them, right? Or if the concept is clear to you, you can always explain that in that way. Okay. Yes, context. So Kuldeep, context, enactment, law, these are the words which are repetitively used in interpretation. So we have to get familiar with that. Yeah. Yes, Mustafa. So mischief rule is also about tackling the loopholes. So people, if they are trying to misuse the loopholes in the law has to take care of that. Yes, law cannot allow people to misuse the law by exploiting the loopholes, right? However, here I will tell you there is a difference between, one is called tax planning and tax evasion. So law cannot permit evasion. What it permits is only planning, right? So this is what the law is about. Okay. Any other questions? If you have. Examples 3 and more not handy. Okay, let me give me a second. Clause 3 example is section 7A of the Securities Act. Whereas in case of section clause 4, it is referring to section 8 of the Securities Contract Regulation Act, and it is referring to all legislations about that. Whatever law, any other law, you see the word is or in any other law for the time being in force having effect. So it is referring to all laws. So you can see here, clause 1 talks about clauses and subclauses in the legislation. 2 talks about the whole enactment. 3 talks about reference to one enactment. 4 talks about reference to everything, all laws. I hope this gives you clarification. Yes. Okay. Right. So when it says other enactment, that means only one law. When it says all other laws, that means all other enactments, everything, all laws. Pro bono. Pro bono means free, or you can say out of pro bono is generally, free legal aid or free legal service. That is referred to as pro bono. Pro bono means public service, you can say. Yeah. Yes, Mustafa, you are in a sense right. Yes. So it is level 1 is basically sections and subsections. Level 2 is the whole law. Level 3 is the comparative any one law. And level 4 is the all laws. Yes, you can say this is pro bono by Harish Shalve. Yes, very true. Yeah. Any more questions? No. Let me check the portal also. There is an admin portal. I have to check whether there are questions. Okay. So Santosh has questions. What questions? I will discuss that in my next class, what questions you will get in the examination. Okay. Any other questions? Any one of you? Okay, then if there are no questions, you can log off, all of you. Thank you for your time. Good evening. And I hope you are following this. Tomorrow we will complete the whole session. Yes, lawyers need to read all cases word by word. That is their job. But CS don't have to. You have to only read your related laws and provisions. But nowadays, you have to also read that in case if you are dealing insolvency matters or insolvency laws. Yes. Let me check whether there are any. Yes, CS also have these details. Yes, I agree. Okay, so we will close the session. Thank you.